Good afternoon, and thank you for joining us for an MP webinar covering wage and hour lawsuits, prevention, best practices, and legal advice. I'm Katie Kreider, Marketing Specialist here at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management company. We offer a complete suite of products and services to support organizations through the entire employee life cycle, including recruiting, HR, payroll, benefits administration, time and attendance, and compliance assistance. We support our clients with cutting-edge technical solutions, as well as proactive, reliable service and a deep HR and payroll expertise. At NP, we are wired for HR and help our clients succeed by aligning their people strategy with their business goals. I'm excited to announce your presenter for today's program, Andreya DiMarco. Andreya's practice focuses on representing employers in all aspects of employment law, as well as advising clients on proper compliance with the law to mitigate liability. While litigation is a central component of Andreya's practice, she also advises clients on daily issues related to policies, personal matters, discrimination, harassment, retaliation, leave, wages, accommodations, and compliance. Andreya frequently lectures on employment-related topics, including leave, workplace harassment, wage and hour, employee handbooks, and other workplace practices. Hatfield Schwartz Law Group is a woman-owned law firm located in northern New Jersey with a practice-centered labor and employment law. Founded by Stephanie C. Schwartz and Catherine B. Hatfield in 2020, the law firm provides dedicated personal attention to each of their valued clients. Hatfield Schwartz was created with the mission to focus on client issues and determine innovative solutions with an unparalleled level of quality. They develop proactive business solutions, assisting their clients with all their legal needs. For more information, including how to contact them, please visit www.hatfieldschwartzlaw.com. And just a quick few housekeeping issues before we get started here today. If you would like to submit a question during the program, please use the Q&A feature at the bottom of the screen. We will be sending out a recording of the webinar later today, along with the slides. And to ensure that your company is prepared for year-end, I'm going to drop a link into the chat for you to book a meeting with an HR professional. And with all of that, I'm going to hand the mic off to Andreya.
Thank you, Katie. Good afternoon. Thanks everyone for attending today. So as you are aware, we'll be talking about wage and hour issues, and specifically we'll be talking about types of employees and proper employee classification, payment of wages and compensation, employees' hours, breaks, time off, and how that impacts wages, and legal implications of improper classification, as well as failure to properly pay your employees. So let's start off with your type of employees. Full-time, part-time, seasonal are your typical employees. And what is a full-time employee? What's a part-time employee? What is a seasonal employee? So that's usually determined by the employer unless your state has a law that says otherwise. So most employers will define a full-time employee as someone who works 35 hours or more a week. And usually this employee is salaried. Part-time employees typically work 35 hours or less a week, or maybe 30 hours or less a week, and can be salaried or hourly. And seasonal is just what you think it was, a seasonal or temporary employee. So someone who is brought on for a temporary period of time, maybe 6 months or a year, and typically brought on for a specific purpose. So employer policies, I always believe that it is important to have in your handbook or a separate policy that defines what a full-time and a part-time employee is, and seasonal or temporary if you have those or hire those, so that employees know what they fall under in terms of what benefits they're entitled to. Most employers offer certain benefits based on the employee's status. So it's important for employees to know whether they are a full-time or part-time employee and what they are entitled to or are not entitled to. It's also important to know the difference between an independent contractor and an employee and ensure that you are classifying them correctly. So an independent contractor is typically paying their own taxes, meaning that the employer does not have to withhold and pay payroll taxes. Additionally, as an employer, you typically do not have to offer employee benefits to an independent contractor, and you do not have to pay an independent contractor a minimum wage or overtime. So how do you define what an independent contractor is, or how do you determine what an independent contractor is? So you want to look at facts or their roles and determine the degree of control and independence that you have over this person. So 3 categories: behavioral, financial, and the type of relationship. So behavioral meaning, does the company or employer have control or the right to control what the worker does and how the worker does his or her job? Financial is, are the business aspects of the worker's job controlled by the employer or the company? So things like how the worker is paid, whether expenses are reimbursed, who provides tools, supplies, or equipment necessary to perform the work. And the type of relationship. So is there a written contract? Is there an employee type of contract? If there is a written contract, does it specify that the worker is to be considered an independent contractor and not an employee? Does the worker get benefits? So are they entitled to things like a pension plan, insurance, vacation pay? Will the relationship continue, or is it going to end? Is it for a certain duration? And is the work performed by the worker a key aspect of the business? So implications of improper classification. If you as the employer classify an employee as an independent contractor and you have no reasonable basis for doing so, then you may be held liable for employment taxes for that worker. Again, you'd have to pay payroll taxes. And there may be other implications such as retroactive pay, retroactive benefits, time off that now has to be provided to the employee, and other employee benefits that would otherwise be provided to your other employees. So employee classification, exempt and non-exempt. What does this mean? How do we categorize it? And what are the implications of this? So whether an employee is exempt or not exempt is not determined by the employer, but it's regulated by the FLSA. So you have to ensure that you understand this and that you are properly classifying your employees. So exempt employees are, in the definition, exempt from overtime. Non-exempt employees are non-exempt, which means that they must receive overtime for all hours worked in excess of 40 hours a week. And we will get to determining what the 40-hour work week is and what they do and don't have to be paid for. So in order to classify an employee as exempt, with a few exceptions, of course, there's always exceptions, the employee must be paid at least $35,000 a year or $684,000 per week. Keep in mind, a little mental footnote is that the $35,000 threshold may increase soon. There is currently a rule pending before the DOL that would increase that threshold. Don't know what the amount would be. There are amounts that have been contemplated between $40,000 and $80,000, so a wide range. I highly doubt it will be as high as $80,000, but it may go up to about $40,000 or $45,000. So in addition to the salary threshold, you want to look at what the employee's duties are. So white collar duties and independent judgment. White collar duties meaning that the employee spends 50% or more of their time completing administrative, executive, or professional tasks. In addition to that, the employee must exercise independent judgment in order to be exempt. So they must be able to make decisions on their own, manage, supervised, in order to be considered exempt. Certain professions are automatically exempt, and therefore you don't even have to look at the duties test. So professions including doctors, lawyers, accountants, nurses, engineers, scientists, teachers, sales professionals, and computer professionals. Again, there's certain caveats, so you want to make sure that you're looking at the DOL's definition of these categories, but generally those are exempt. So payment of exempt employees and non-exempt employees. Exempt employees are not entitled to overtime, as we discussed. So they're typically going to be salaried employees, meaning that it doesn't matter if the employee is working 30 hours a week or 60 hours a week, they will be entitled solely to their salary, unless as the employer you decide to give them bonuses or other sort of benefits, but they are not entitled to overtime pay, no matter how many hours a week they are working. Whereas non-exempt employees are entitled to overtime pay for any work in excess of 40 hours a week. So what is a 40-hour work week? That is something that is determined by the employer. So it can be any 40 hours in a 7-day period. It could be your typical Monday through Friday, 9 to 5. It could be Monday through Friday from 12 to 8. It could be Sunday through Thursday from 9 to 5. You as the employer can determine what the 40-hour work week is, and you can vary it based on different groups of employees. You just have to make sure that you have a policy that clearly states what the 40-hour work week is and ensure that your employees are fitting into that category, or that you are otherwise tracking how many hours an employee is working and what their 40-hour work week is. So something to note is that the FLSA does not require overtime pay for work on Saturday, Sunday, or holidays, or other days of rest, just because it is falling on a Saturday, Sunday, or a holiday. However, if an employee is working over 40 hours a week, so if the employee is normally on a Monday through Friday 9 to 5 schedule, if they work on a Saturday and they are now in excess of 40 hours a week, then yes, you have to pay them overtime. But if the employee's 40-hour work week includes Saturday through Thursday, then you do not have to pay them overtime, just because their normal work week is falling on a weekend. So determining other hours, so about on-call time, sleeping, lectures, meeting, training, travel time, rest, and meal periods. So on-call time, an employee is required to remain on call on the premises while working on call is entitled to pay. What about if an employee is sleeping? If the employee is required to be on duty for less than 24 hours, then all that time is compensable, even if they're permitted to actually sleep during that time. If an employee is required to be on duty for more than 24 hours, then the employer and employee may agree to exclude sleeping time from compensable pay. However, sleeping facilities must be provided if the employee is on site. Lectures, meetings, and training programs. This is generally all compensable unless it is not job related or not otherwise connected to the performance of their duties. Travel time, of course, time traveled to and from the office or to and from work or to and from a meeting is not compensable. However, if it is time that is traveled during the workday, so if they're going to a meeting to and from the office in the middle of the day, that is compensable time. If it's time spent traveling on a business trip, that can be compensable time as well. Rest and meal periods. So rest periods of a short duration, usually 20 minutes or less, the FLSA will define them, are customarily paid as working time since they are such a short duration. Bona fide meal periods, so your typical 30-minute lunch period, generally does not need to be compensated. However, if the employee is performing any work during that time, so you have employees who maybe eat at their desk and they're simultaneously eating and working, then that is compensable time. So what about determining payment of overtime? As most of you know, overtime has to be paid in at the rate of 1.5 times an employee's regular rate of pay. So determining the regular rate of pay is determining it based on either their hourly rate, a piece rate, or a salary rate. Something that's always asked, a question that typically comes up, is whether non-discretionary bonuses must be included in an employee's regular rate of pay. And the answer to this is yes. If an non-exempt employee is given a non-discretionary bonus, meaning the bonus has a specific criteria that needs to be met in order to be paid that bonus. So if an employee bills X amount of hours and the employee brings in X amount of revenue, they will be paid this non-discretionary bonus. If it is a non-exempt employee, that discretionary or non-discretionary bonus must be included in the employee's overtime rate for that pay period. Another question that often arises is, what if an employee holds 2 positions with the same employer? So if an employee holds 2 positions with the same employer, then you must use a blended rate to determine what their overtime rate would be. So when a non-exempt employee takes a second, say, part-time job with the same employer, they must be compensated at a time and 1/2 overtime rate for any hours worked over excess of 40 hours a week in this blended rate. So if the employee's primary role is a non-exempt position and the second role is an exempt position, then it doesn't matter. They still have to be compensated for that overtime as long as they are still working 50% or more of their time in non-exempt duties. So the impact of improperly classifying an employee as exempt or non-exempt is that it can adversely affect you as the employer and compensation that may be owed. So misclassification could result in regulatory enforcement action, fines and penalties, lawsuits for unpaid compensation, and additional cost to remedy the misclassification, so retroactive pay or further penalties. Sometimes the employer may have to reclassify an employee if their duties change, if the position changes, or if they had improperly classified them to begin with. And this is okay. You just want to make sure that you are putting the employee on notice that you are now going to reclassify their position. We always recommend consulting with legal counsel before you do this to make sure that it is done properly, to make sure that you are now properly classifying the employee, to make sure if there is any other retroactive pay or benefits that are owed, that is being accomplished, and to make sure that you are handling it correctly, meaning that you are having the correct conversation with the employee, and anything that's put in writing is also properly drafted to mitigate and avoid any legal liability. So what about remote employees? So laws vary by state, and you'll need to determine whether the employer, you as the employer, is required to follow the laws in the state that your business or your company is located, or in the state where the employee is located or working, if the employee that is working remotely is in a different state, or both. So some laws to consider are different tax treatment of employee benefits, payroll taxes, unemployment insurance, workers' compensation laws, minimum wage, family and leave laws, sick leave, and payday or paychecks, how you're paying the employee. So payroll taxes. Normally, payroll taxes must be paid in any state in which the employee performs work and is physically present in the state. So usually the employer will need to withhold state income taxes for the state in which the remote employee lives and works. However, again, you want to make sure that you are reviewing all laws, whether you're doing it yourself or doing it with counsel, because you want to make sure that you are not required to pay payroll taxes in 2 different states. Unemployment insurance. In conjunction with payroll taxes, you need to make sure that you have unemployment accounts established in each state in which an employee works so that they can properly file as needed. So this means that if you have several remote employees and they work in various states, you need to ensure that you have unemployment accounts set up in each of those states. Workers' compensation. All states have their own workers' compensation laws and procedures. So you also usually need to establish workers' compensation insurance accounts in each state in which an employee is physically working. Keep in mind, misconception and something that we have been learning in this new remote world is that an employee that is injured on the job while working remotely can be entitled to workers' compensation. So keep that in mind. Garnishment or pay deductions, that varies by state. So again, you want to make sure that you are familiar with the state laws that the company is based in, as well as any state laws that a remote employee is based in. Minimum wage, this varies widely by state. So again, you want to make sure that you're familiar with the minimum wage amounts in the state that you are in, that your company is in, as well as the state that any employee is working in, and determine what minimum wage laws need to be followed. Family and medical leave, this varies widely by each state. So you want to make sure that you are not only complying with any federal family and medical leave laws, but that you are familiar with state laws in the state that your company is based in, as well as in the state that any of your remote employees are residing and working from. And again, making sure that you are following the laws correctly. Do you have to follow the law that you are physically in, or do you have to follow the law where your employee is located in? Sick leave, again, this varies widely by state. Some states don't have any sick leave laws. Other states have very strict mandatory sick leave laws. So you want to make sure that you're familiar with all sick leave laws in all applicable states and ensure that you are following them. paychecks, again, not only do you want to make sure that you are familiar with the federal law, make sure that you are familiar with any state laws regarding paychecks, how they are issued, when they're issued, and what is required. Some states require you to include vacation and sick leave pay as wages, while others don't. Some states require you to pay employees within a certain period of time, while others don't. Some states require you to issue a final paycheck, and if an employee leaves, whether voluntarily or involuntarily, within a certain period of time, other states do not. So you want to make sure that you are familiar with all of those laws and that your employees are not only being paid proper wages, but are being paid on time. So payment of actual wages and determining what is considered wages and how you're paying your employees. So what is considered wages under federal law, the FLSA, does not require pay or compensation for vacation, holiday, severance, or sick time. However, most employers choose to offer these to their employees. Of course, most employers offer paid vacation, at least certain amounts of time for paid vacation, paid holiday, severance probably depends on the size of the employer and the conditions of leave, and sick leave that varies by state. So even though the FLSA does not require it or the federal law does not require it, you want to make sure that you are familiar with state laws. So full-time employees versus independent contractors, and we touched upon this before, but your full-time employees are being compensated properly, and of course always have to be compensated with at least minimum wage, determining whether your employees are exempt or not exempt to determine whether they are entitled to overtime, and making sure that you are issuing the proper statements. So typically a full-time employee or a part-time employee is going to be getting a W-2, whereas an independent contractor will be getting a 1099. And again, independent contractors, you do not have to pay them minimum wage. You do not have to pay them a salary. You do not have to pay them bonuses. You don't have to provide benefits. It is usually a contractual agreement between the employer and the independent contractor as to what they will be paid and how they will be paid. So remote work, employees, of course, must be paid for time spent while working remotely. And the biggest issue that we have seen with remote work is just properly tracking employee time. So if it is a salaried employee, this probably does not matter as long as the employee is, of course, getting their work done and they're available when they need to be available. Then you don't need to necessarily track their time because the employee is going to be paid the same salary regardless of what type of how many hours they are putting in. However, with your hourly employees or your non-exempt employees that are entitled to overtime, you want to make sure that you have a proper policy or procedure in place that allows you as the employer to track the employee's time. So whether this is requiring employees to submit timesheets, whether it is having some sort of software that monitors time that an employee is logged on or logged off, whether it is asking employees to report in the middle of the day and sign out at the end of the day, or you're just working on an honor system, whatever works for you as the employer and your company. Just want to make sure that it is properly, there's a policy that's in place, the policy is being enforced, and that employees are following it. And again, the biggest issue here is that for non-exempt employees, if you have employees that are working remotely, they're not exempt, they're still entitled to overtime pay. So if you are not properly tracking their time, and they are working beyond 40 hours a week, despite the fact that it is remote work, and you are not properly paying them overtime, you could find a lawsuit against you, and you could certainly be liable for retroactive wages, as well as any penalties that may come with that. So overtime pay versus comp time. Something to keep in mind is that as a private entity or private employer, you generally cannot offer comp time in place of payment for overtime. If you are a public employer, then the DOL does permit you to offer comp time in place of overtime, meaning that the employer and employee can agree that instead of receiving extra pay for hours worked in excess of 40 hours a week, they will receive extra time. So if they worked at 10 extra hours in a week, the employer can provide them with 10 hours of comp time or additional time as may be agreed upon between the employer and employee. So wage deductions. Deductions from pay are permissible when an exempt employee is absent from work for 1 or more full days for personal reasons other than sickness or disability. Absence for 1 or more full days due to sickness or disability if the deduction is made in accordance with a bona fide plan, policy, or practice providing compensation with salary for lost illness. To offset amounts employees receive as a jury or witness, or for military pay, for penalties imposed in good faith for infractions of safety rules or major significance, or for unpaid disciplinary suspensions of 1 or more full days imposed in good faith if the employee violates a workplace rule or policy. So again, this is a little nuanced. You want to make sure that you properly understand the law as to what can and cannot be deducted from an employee's pay. And before I forget, employees can also deduct certain expenses from employees' pay, such as expenses for uniforms, property theft, or damage, as long as the deduction does not cause the employee to dip below whatever the minimum wage is in that state. So expenses for reimbursement, well, this is generally not required. You want to make sure that you are checking your state laws to determine if you are required to provide your employees with any reimbursement for certain expenses. So expenses may be expenses incurred with travel, so gas, hotel, flights, or office expenses. So expenses for office supplies, for computers, anything that the employee may incur in furtherance of performing their job. You want to make sure that you check with your state law to determine if you are required to reimburse the employee for those costs that they incur. Or as an employee, you can certainly decide to put together a discretionary policy, which states that you will reimburse your employees for certain expenses that they incur in furtherance of performing their job duties. Separation from employment, of course, employees are always entitled to pay when they separate from employment for any work that has been performed through their day of termination. In terms of issuing their final paycheck, you want to make sure that you are familiar with state laws to determine when the final paycheck has been issued. I know we have seen with some clients where they will withhold the final paycheck because the employee never came to pick it up, or because there is an issue that they are trying to work out with the employee over something that occurred that led to their termination. However, in most states, that's not proper. Many states will require that the employee is issued their final paycheck within 2 weeks of their last day of termination, or within X amount of time of their last day of termination. So you want to make sure that you're familiar with the law, and if the employee doesn't come pick up their paycheck, then you mail it to them. So tracking employee hours, and we touched upon this a little bit, but employee hours for remote work, again, you just want to make sure that you have a proper policy and procedure in place for making sure that you are able to properly track hours that a remote employee is working. Regarding minors, we get many questions about employee hours for minors, and this information is easily available on federal websites, and you want to, again, ensure that you are looking at your state laws, consulting with legal counsel to determine if there are any specific laws in your state that are different from the federal laws in place. But in terms of federal laws, the FLSA sets forth minimum hours that can be worked for employees that are 14 years old, 15 years old, and 16 years old. So you want to make sure that you are familiar with that. If you're employing any minors, make sure that you are not violating the law by having the minors work more hours a week than they are permitted to work under the law, or work beyond certain hours. So the law generally says that minors can only work X amount of hours a week, and that they can't work past a certain time. So Monday through Friday, because it's a school night, they can't work past 11 p.m. You want to make sure, though, as stated, that you are also checking your state laws, because there might be something a little bit more restrictive in place in your state. Also, something to keep in mind is that minors are non-exempt, so they must always be paid overtime. And that's assuming that they can even work beyond 40 hours a week, depending on their age. So meal and rest breaks. Again, I think we touched upon this, but federal law does not require you as the employer to provide lunch or coffee breaks. However, when you do provide short breaks to employees, usually 20 minutes or less, they are compensable and you generally cannot deduct that time from the employee's pay. Vacation or holidays, we touched upon this, and other time off. The FLSA does not require employers to pay employees for holidays, vacation, or other time off. However, there may be state laws in the state that you are located that does require this type of pay. So you want to make sure that you are familiar with that. And in general, most employers, of course, do provide this type of pay to their employees. Employer policies. It's always a great idea to have policies in your handbook or separate standalone policies which state exactly what employees are entitled to and what they are not entitled to. So if your full-time employees are entitled to 2 weeks of vacation a year, you want to make sure that that is clearly set forth in the policy. If your part-time employees are entitled to less, you want to make sure that that is clearly set forth in the policy. And you want to make sure that it clearly says that it is paid vacation or non-paid vacation, paid leave, non-paid leave, and holidays. Always a good idea to put forth the holiday schedule so that employees know what days they have off and what they are entitled to pay for. The same goes with sick time and other leave time. You want to make sure that you are not only familiar with federal laws, so the FMLA, but that you're familiar with whatever sick leave laws are in place in your state. So in New Jersey, for example, there is a law that says that generally employees must be provided with 40 hours or 5 days of sick leave per year. You can either front load this or employees can accrue this time. However, they must be entitled to that time maximum. You don't have to provide more than 40 hours, but up to 40 hours. And they are entitled to sick leave for certain reasons, meaning that the employee cannot deny sick leave if the employee is looking for leave based on those specific categories or reasons that fall under the law, barring certain caveats and exceptions in the law. So state family leave laws, again, we have the Federal Family Medical Leave Act, which requires employers that have 50 or more employees within a 75-mile radius to provide 12 weeks of leave in a 12-month period for certain qualifications under the law. While you don't have to pay your employees for that leave, you do have to provide job protected leave. Generally, the employee can seek supplemental wages through the state if your state offers those benefits. Many states have their own family and medical leave laws in place, which also require the employer to provide certain amounts of leave, so a certain time of leave to employees for certain reasons. So again, I'll use New Jersey as an example. They have a law that requires employers 30 or more employees to provide leave to employees in the amount of 12 weeks of leave in a 24-month period for certain reasons that pertain to the employee's medical condition or family medical condition or other qualifying reasons under that law. And again, that leave does not have to be paid by the employer. It is just job protected leave that must be offered to the employee. And in New Jersey, there is supplemental benefits that are available to employees who are on family or medical leave. It's always a good idea, again, to have these policies in place in your handbook or standalone policies that state what the state law is, if there is any, what the FMLA states, what the employer is required to provide and what employees are eligible for and not eligible for, and make sure that employees understand whether that leave is paid or unpaid, so they are not looking to challenge you as the employer for something that they are not actually entitled to. So some other considerations are just making sure that you as the employer have the proper posters in your workplace. So you want to make sure that you're familiar with Department of Labor guidance and any state guidance that requires you to post or disseminate certain notifications in the workplace to employees, informing them of their rights about wage and hour laws and certain leave laws. And legal implications. So summarizing, why do we want to know all this? So if you are improperly classifying your employees or you are not paying them the proper wages that they are owed or providing them with proper leave time, the employee certainly has a right to bring a complaint with the DOL and or a state agency seeking payment for unpaid wages. Unlike your typical litigation, these type of cases cannot be settled because an employer cannot agree to pay an employee less, and an employee cannot waive their right to unpaid wages. So it's not like any other matter where your typical litigation, as a former employee may bring a case against you for improper workplace conduct, wrongful termination, and they may seek various compensatory damages as well as, say, emotional damages. And emotional damages mostly are going to be an arbitrary number. And they may seek punitive damages, which is an arbitrary number. That's not the case here with any sort of a wage and hour complaint that is filed. The employee is entitled to their proper wages. That cannot be reduced, that cannot be settled, that cannot be waived. So no settlements in these type of matters. And as we discussed today, not only may you be responsible for paying the employee for retroactive wages that were due, that were not properly paid, but you may be hit with fees or penalties. Also, the time that goes into these is usually just a pain and something that employers don't want to deal with. It is time consuming. It requires going back and going through all of your HR documents, going through hours that employees have worked, tracking those hours. If you have an employee that has been there for years and they have been improperly classified or improperly paid for years, it is extremely onerous, burdensome, and time consuming to go through those documents for years. And it is something that the employers don't want to have to be saddled with. So in order to avoid that and mitigate that, you want to just make sure that from the start of employment, you are properly classifying employees and paying them proper wages, meaning that you know what you have to pay them and you are properly tracking hours. Again, you should always consult with legal counsel if you have any questions about classification, what hours an employee has to be paid for, and what wages they have to be paid. So some takeaways from today, to summarize: you want to ensure that your employees are properly classified, ensure that non-exempt employees' hours are properly tracked, ensure non-exempt employees' pay rate is properly calculated and paid, ensure non-exempt employees are paid overtime when due, ensure that all employees are paid proper wages and given proper time off. And make sure that you are training your HR and your management to ensure that these laws are being enforced and that time is properly being tracked and paid. And when in doubt, consult with legal counsel. Okay, that is all I have for today. I will review some questions that were being asked. So what if I want to reward an exempt employee for additional work? Is this permissible? Yes, this is permissible. You can generally pay a bonus, whether discretionary or non-discretionary. Are pay raises required? If so, when? So pay raises are generally a matter of agreement between an employer and employee, or generally at the employer's discretion. So pay raises to amounts above the federal minimum wage are not required by the FLSA. Most states don't require this either, but again, you want to make sure that you are checking with your state for proper laws. So is the blended rate an average of both hourly rates? So yes. So if you have an employee who works in two different positions for the same employer, excuse me, you want to make sure that you are using that blended rate. And I will try to come up with an example because that might be easier. So blended rate, average rate of the two pay rates. So if you have an employee that works in a position A and that rate is $10 an hour, position B is $20 an hour, you want to use the average of those and then pay that in excess of whatever their hours are for that week. So overtime versus comp time. So just a general summary, since they missed that. Generally, private entities or private companies cannot offer comp time in lieu of overtime compensation to their employees. However, public entities, public sectors can offer this, meaning that if you are a public sector employee, you can have an agreement with your employees where you offer them comp time instead of offering them overtime. Many public sector employees will have both, and so they'll allow their employees to decide if they have worked overtime for that specific week, whether they want to receive overtime compensation or whether they want to receive comp time instead of monetary compensation. Okay, so I'm going to turn it back over to Katie at MKHR, and if there are additional questions, I will reach out directly.
Thank you so much, Andrea. To learn more about MP's HR services for 2023 and more, I did drop a link earlier into the chat that will connect you with an MP team member. You can visit us on our website or call 774-266-6497 for more information. Be sure to join us next week on our upcoming webinar, Mastering the Remote Office Holiday Party. Visit our website to register and to see the full calendar of upcoming events and available resources. We will be sending out a recording of today's webinar with the presentation slides this afternoon. Thanks for joining us and have a terrific day.